Hello, this is Matt on the Moon Lambeau channel. I want to share with you perspective from 3 attorneys within the XRP community. That'll be Attorney Bill, Attorney Jeremy Hogan, and Attorney John Deaton. On the topic, to start anyway, of the SEC just blatantly lying to the judge. And that's how I'm characterizing it. I've seen attorneys, write that the SEC is effectively mischaracterizing Ripple's position on various things. And, I mean, that's tantamount to lying from my in what they're doing. And in my video recently, I think it was the one where it was like over 40 minutes long, and I was breaking down the Ripple's opposition to the SEC's motion for summary judgment. I mean, I highlighted multiple examples, clear proof, as pointed out by Ripple, that the SEC is intentionally misleading the judge. This isn't an oops-a-doodle one-off instance. They keep doing this again and again and again and again. And they're just hoping that they trick the judge. That's all I can imagine. What else would it be? Now, the good news is both judges in this case, and most importantly, Judge Torres, these judges are not stupid. I don't think they're falling for this BS from the SEC, but still the SEC keeps trying this nonsense. So I'm going to share with you some perspective, as I said, from a few attorneys, but before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, you may also recall that not only did Ripple file an opposition to SEC's motion for summary judgment, but the SEC filed a legal brief in opposition to Ripple's motion for summary judgment. And here is what Attorney Bill of the XRP community has to say about this. I have now had a chance to properly consider the SEC's reply to Ripple arguments on the need for certain essential ingredients, including a contract, for there to be an investment contract. So I'll just pause to note, and this is like, and it's become very clear lately, Ripple's starting argument effectively in this case is that there can be no investment contract because there is no actual contract. And an investment contract is a type of security. There are different types of securities. So at the heart of this is whether or not XRP represents some sort of investment contract. And again, given that there aren't contracts other than specific contracts that Ripple has with key business partners, because mind you, they didn't sell to end users, they never did. They have contracts with specific key partners, but there are no post-sale obligations on those. So even those wouldn't apply, even if you say, well, there are contracts there. Well, there's a reason the SEC is not talking about that. It's because it doesn't apply, and there's nothing else anywhere. The SEC doesn't find anything else anywhere. And Ripple's attorneys are arguing, as a matter of fact, that just as a matter of law, this is fatal to the SEC's case. Anyway, Attorney Bill continues. The SEC goes to some lengths to mischaracterize Ripple's attempt to construe a non-defined statutory term investment contract by reference to pre-1933 blue sky law cases as it's Ripple's own manufactured test. There is a lot of rhetoric using words such as extremist argument, radical proposition, far-fetched theories, reactionary argument. I find this language to be undergraduate and unnecessary and a sign of weakness in legal argumentation, but perhaps it is acceptable in the United States in making written legal arguments. There are only 2 points the SEC makes that I think are strong. And I'll pause a note here. As far as the strong language, you don't tend to see that from Ripple. And there are some instances where they do kind of punch back, but look at what happens with the SEC. What do? Well, they have, first of all, obviously they have the weakest damn case you could possibly imagine, which is why I cannot imagine hardly this going in the SEC's favor just in a general sense. But that's also why they, if you go to their initial legal complaint against Ripple dating back to 2020, they were talking about a bunch of stuff that has nothing to do with the core issue of the case. Is there an investment contract? That's the core issue of the case, right? They argued all sorts of stuff that isn't illegal. They used fraud-like language to describe how Ripple, Brad Garlinghouse, and Chris Larson are selling XRP. But it wasn't illegal. They didn't assert any actual fraud. There was nothing illegal in that sense, other than their, of course, the SEC is claiming that all those sales are on, investment contracts. But in terms of actual fraud, no, there is no fraud. This is a non-fraud case. So the SEC, from the very beginning, having such a weak argument, they'll just put all sorts of stuff in their legal briefs. They consistently have done that. Anyway, Attorney Bill continues. Again, he said, there are only 2 points the SEC makes that I think are strong. Firstly, Ripple may have a weakness in confining the term scheme the way it does. The Ripple argument is that transaction or scheme merely conveys that a court should look at the broader context in which the instrument is grounded. The SEC points out that Ripple cites no case that holds this to be the case. Secondly, the SEC points out that Section 5 of the Securities Act prohibits unregistered offers, not just sales, and an offer until accepted and with consideration is not a contract at common law. And the argument that prohibition of offers would not have been included if Section 5 was only concerned with legally enforceable contracts has some force. Now, apart from those couple of points, I think the SEC has not really raised a strong argument in response to Ripple on this issue. It would be it would be in a better position if it was targeting specific Ripple sales or offers of XRP and not running this absurdly broad case of targeting all XRP sales or offers for 8 years, including in secondary markets. Yeah, and it is truly amazing. They're not citing, and it should be done. They should be citing specific sales. But part of my theory as to why they're not doing that is because if they cite specific older sales, even if they could win on that, and that's an if, but even if they could, then what about moving forward? Because the SEC wants control over all this. That wouldn't give them control. So my suspicion is that that's at least in part what's going on here. Now, Attorney Jeremy Hogan responded to that and said, I wanted to talk about this in the video, but really didn't have time. These are horrible facts for the SEC exactly because they waited 8 years to bring the action. Again, makes you question why this case was brought in the first place. Yeah, exactly. Well, I'll go back to what Attorney John Deaton said, I think probably in the beginning of 2021, which is that it looks like this case was used as a weapon. But yeah, you're right, Attorney Hogan. It does make you wonder, why are they doing it? Speculation being no good reasons, used as a weapon. And then XRP community member JV wrote to Attorney Bill and said, that's what I mentioned to John Deaton yesterday. What if the SEC is only taking this broad approach, to make sure they don't miss any type of sale that could potentially be unlawful? Wouldn't it now allow the court to analyze all sales and not just specific sales? Which is a perfectly reasonable question from JV. And my non-legal mind, because I have no legal background, went to where Attorney Jeremy Hogan's did. Because I'll tell you what I was thinking initially. I was like, okay, maybe that's the strategy, but I personally didn't think that's necessarily the most likely. Reason being is you'd have to have the judge then look at every single transaction. Aren't you putting the onus on the judge? And is that a good strategy? So that's why I'm like, I think it's more so because the SEC is overreaching here. I think that's why they took the approach that they did, and they're just hoping for the best. They're slinging crap at a wall and just seeing what sticks, basically. So Attorney Hogan responded to that and said, possibly, but then what you are doing is throwing a bunch of crap at the judge and saying, you figure it out. A prosecutor is supposed to figure that stuff out before filing the lawsuit. Attorney Deaton then responded to that and said, the good news for Ripple is that the SEC didn't offer any specific sales with contracts and alleged that although it may be to an accredited investor, it was subterfuge to get to the secondary market. No specific transactions, just all transactions. I don't see how it sticks. Yeah, and so Attorney Deaton's point is well taken. If you look at legal precedent, I don't know how this is good for the SEC. I don't see how this approach is a winner for the SEC. And John Deaton there, to be clear, he's pointing out that the SEC did not argue that the sales that Ripple made, which were to key strategic partners, the SEC did not argue that those sales were some sort of trick to get XRP in the hands of people like you and me. They did not argue that. They're just saying everything just is. Everything just is. It's a illegal securities, unregistered securities transaction. Just everything is. And then there's also this. Attorney Hogan wrote, the SEC fails to adequately address the post-loss obligation argument as raised by Ripple. I kept waiting for a slew of cases in which appellate courts have found no obligations necessary and nothing. Game-changing argument by Ripple. And I'll also note what we're talking about here, is that's his comment in response to the SEC having filed its legal brief in opposition of Ripple's motion for summary judgment. And so there, Attorney Hogan is saying, kept waiting to see what, where's the SEC going to bring up, cases that, that might be, I suppose in some terms, binding in some way, or at least precedent setting, even if not binding. But there's no case law. They're just making claims. And then Attorney Hogan says, correct me if I'm wrong, but the only case it cited on point was the Kick Interactive case, which, number one, is not binding precedent, and two, a case in which the issue was not even raised. I feel like I'm missing something, and the SEC keeps talking about written contracts. Yeah, keeps talking about written contracts, but that was, again, as Attorney Bill pointed out, Ripple's not talking about that. They're mischaracterizing, what Ripple's stating, which to me is a lie. They're lying about what Ripple is doing. They know what they're doing. The SEC knows that they're lying assets. What a bunch of pricks. And then somebody named Carrot Chaser wrote to Attorney Hogan and said, can you explain this to me like I'm a 5-year-old, please? And somebody from the community named Zero responded and wrote, the SEC fails to find previous cases that support its arguments about what constitutes an investment contract. Exactly. So the SEC making these claims, but can't back it up with any sort of precedent, which is a big problem for them. Attorney Hogan responded to Zero and wrote, that is super succinct. Nice. And then there was this. Somebody named Unsinkable2 said, haven't read all of it yet. Are they referring to written contracts from a discovery perspective? And Attorney Hogan says, no. The SEC is reading post-loss obligations as written obligations, and that wasn't Ripple's argument at all. It completely misses the mark. Or maybe it just couldn't find anything, so it tried the Chewbacca defense. I do love that. It's a good South Park reference. You'll have to Google that if you're not aware of what it is. Good old Chewbacca defense. You know why? It's because Wookiees do not live on Endor. It does not make sense. So there you go. As Attorney Hogan saw the same thing that Attorney Bill saw. The SEC is, if you want to word it lightly, and it's fine. It's not to critique the attorneys within the XP community. If you want to word it as mischaracterization, it's not that that's incorrect. But I'll go a step further and just say that, in my opinion, they're lying to the judge. That is the effect of this. They are lying to the judge about what Ripple is saying. And they have to know. And the reason I say lies is because I believe they know it. I don't believe this is an oops-a-doodle. I think that these are terrible humans. Let me know what you think in the comments section below. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.